Contrary to the beliefs of many, most individuals with mental illnesses are nonviolent. Also, when involved in an encounter with a police officer, it is not uncommon for these persons to fail to comply with the officer's demands. Often this may be due to confusion or some other aspect of the individual's illness rather than a disdain of the law. Research has indicated that more seasoned veteran officers are often aware of this, and they are usually less likely than less experienced officers to make an arrest. Compliance is also more likely to be obtained in situations involving one rather than two police officers. In fact, when there is more than one police officer, this is more likely to result in a situation where either an officer or the individual who is mentally ill may become injured. Verbal communication skills are often helpful in diffusing these situations, and while it is likely that an encounter with an individual who is mentally ill may prove to be stressful, officers must remember that this illness is a mental disease rather than a choice. Generally speaking, police officers have been found to be more empathetic towards persons with mental illness than the general public. It is believed that the first few seconds of a police encounter with a person with a mental illness is considered to be the most critical. If an officer is able to establish rapport with the subject, this could go a long way toward diffusing a potentially violent situation. As first responders, police officers who encounter mentally ill persons may choose to make an arrest, handle the matter informally, or refer the individual to a mental health facility. The latter can be done through civil commitment, where the subject is involuntarily hospitalized. In some jurisdictions, though, it may be especially difficult and time-consuming to commit an individual to a mental facility against his or her will, so officers may find an arrest to be a much more expedient option. And some officers are likely to view these arrests as mercy booking, since the subject will be taken out of a toxic environment and at the very least be given basic amenities and maybe an opportunity to bathe. Nevertheless, the authors of this book argue that the ultimate goal should be for justice officials to get individuals with mental illnesses the help they need in order to ensure that they do not recycle through the criminal justice system. In many jurisdictions throughout the country, even if an individual has committed a crime, if he or she is believed to be mentally ill or unstable, it is possible that the subject can be diverted to a mental health facility prior to an arrest and charges being filed. Some cities utilize mobile crisis teams where both police and health providers respond jointly to mental health crisis situations. The Memphis Police Department has a particularly efficient crisis intervention team. Other police agencies throughout the nation have emulated the Memphis CIT model, where in the spirit of therapeutic justice, the ultimate goal is diversion and improved treatment. Research also indicates that CIT training has resulted in fewer shootings of persons with mental illnesses by police officers. CIT training engages clinicians from the local community as instructors to discuss their areas of expertise, such as signs and symptoms of mental illnesses and psychotropic medications with law enforcement officers. While CIT programs have become popular throughout the country, there is concern that these programs should avoid becoming too centralized or bureaucratized. If this was done, there's a strong possibility that the little nuances and proclivities of a particular local jurisdiction could be lost. While individuals with mental illnesses can be diverted from the criminal justice system before they are even arrested, there are also opportunities for this to be done at the adjudication stage of the justice assembly line. Mental health courts, which are disproportionately scattered throughout the southern and western United States, minimize punitive approaches while attempting to maximize treatment options. If one was to walk into a mental health court, he or she would see a very different environment than in a traditional court setting. Often in mental health courts, there is much less of an adversarial culture. Instead, there is a spirit of cooperation between justice and mental health officials, and the judge often acts as a coach or facilitator rather than as an arbitrator. In mental health courts, even the prosecutor is on board, as he or she understands that in the long run it is in the community's best interest to have long-term treatment, as opposed to a constant recycling of mentally ill individuals or frequent flyers through the revolving doors of the criminal justice system. It does no good if mentally ill individuals languish in prison because of their illnesses. If the problem goes unchecked, seriously ill prisoners are likely to cycle endlessly between prison and the community, and their illnesses are going to worsen, and the chances increase that they will end up winding up in high security units within the prison system, which are extraordinarily costly. Given this, it would behoove administrators and benefit taxpayers to explore more fiscally sound and effective alternatives to incarceration through mechanisms such as mental health courts. While most mental health courts operate in a spirit of therapeutic justice, it is important to remember that there is a considerable amount of variation from jurisdiction to jurisdiction. For example, some courts handle only misdemeanors while others only handle felony cases. And some courts will insist on a guilty plea, whereas other courts defer prosecution as long as the individual is compliant and follows the directives of mental health providers. Interestingly, there is evidence that public defenders may occasionally be resistant to mental health courts, particularly for their misdemeanor clients. For example, from a purely legal perspective, they might believe that their client's short-term interests would be better served by completing a quick stint in jail rather than having to be compliant with longer-term treatment conditions. Still, research has shown that most jurisdictions rarely use jail as punishment for not complying with treatment requirements imposed by the court. Also, charges are often dismissed after successful adherence to treatment regimens. It should be noted that mental health courts are not perfect. For example, some courts have very little control over the caliber of the services dispensed. This has become such a problem in some jurisdictions that judges have taken action against mental health providers that did not satisfactorily meet court requirements and requests. Also, some critics have argued these courts to be too coercive and argued that they could lead to potential net widening. Others express that persons who are identified as mentally ill through proceedings of a specialized mental health court may be stigmatized. And some critics even suggest that the informality of mental health courts have eroded individual civil liberties. And also confidentiality issues may be problematic to some degree. While scholars have argued that federal confidentiality laws or HIPAA requirements might impede communications between law enforcement and mental health officials, HIPAA covers entities. They don't include the court system, court personnel, or law enforcement officials such as police or probation officers. And so protected health information can also be shared between a treatment and a law enforcement agency in most cases. Also, in states such as Texas, actual laws have been passed that allow new jail detainees to be cross-listed with the client lists of various mental health centers across the state. Just to be sure, if an individual is deemed to be confident, he or she can also sign a waiver to allow the release of mental health assessments and records. And families of persons with mental illnesses are also not bound by the doctor-patient privilege and can be a good source of information. Also, even if HIPAA requirements do result in a violation Any repercussions would be minuscule since individuals cannot bring suit for alleged violations. Having said this, if an individual is diverted either through a pre-booking procedure or by means of a mental health court, confidentiality should be assured. It would be inappropriate, for example, for a health provider to provide privileged information to a person's place of work. Also, in mental health courts, information which is divulged as part of a treatment strategy should not be used later against an individual who is returned for routine criminal processing. Clearly, there are numerous issues involved in diverting individuals from the criminal justice system. Of course, not all persons with mental illnesses are diverted from the CJ system. Next week, we will examine the processes by which many of these individuals are discharged from the criminal justice system and released back into society.